Hi, everybody. Welcome to Trial Alchemy. I'm your host, Monty McIntyre. I've been a California civil trial lawyer since December of 1980 and a member of the American Board of Trial Advocates of ABOTA since 1995. Most of my career I spent trying cases representing plaintiffs and defendants in lots of different areas, ranging from business to insurance bad faith to real property and to a lot of tort cases. These days, I help lawyers get excellent results in three ways. First, I help them settle cases as a mediator, decide cases as an arbitrator, and decide issues as a referee. And I do this work at ADR Services. Second, I help lawyers keep up with the new case law in California in their practice areas with my online publication, California Case Summaries. And that provides one paragraph summaries of every new California civil case published throughout the year. I also help lawyers become better trial lawyers with my trial mentoring services and with this podcast, where I interview outstanding plaintiff and defense and civil trial judges, lawyers, and judges who are members of ABOTA, and we talk about what works and what doesn't work when trying a case to a jury. Now, this podcast is brought to you by California Case Summaries, and this publication helps lawyers save time, know more, and win more. These days, when a lawyer mediates with me for a half day or a full day in a private mediation, they can get a 1 year free subscription, which is a $1,999 annual value. So that's a pretty good deal. And law firms who want to get the unlimited rights to send summaries to all their attorneys, they can get a free 1 year law firm subscription when they have lawyers in their firm have two half-day or full-day mediations with me, and that's a $6,500 value a year. Now, today I'm delighted to have as my guest Pam Traut, and she's an outstanding plaintiff's lawyer and a member of ABOTA who lives in Orange County. Pam has 30 years of experience as a lawyer, and she's been with Traut Injury Law since 2014, where she does exclusively plaintiff's personal injury and medical malpractice work. But she has a lot of insurance defense work, having been a partner in an Orange County insurance defense firm where she practiced for 18 years. Now, Pam's been involved in numerous jury and bench trials throughout her career, and she's represented both plaintiffs and defendants. She was the 2024 president of the Orange County chapter of ABOTA. In 2026, she will be the vice president of the National Foundation of ABOTA, and she also serves on the board of what we call CalABOTA, which is a board representing all the ABOTA chapters in California. Now, Pam was honored to be named the Orange County Women's Lawyers Association Attorney of the Year this year in 2025. In 2018, she was inducted into the Western State College of Law Hall of Fame, and she has served in the past as the president of the Robert A. Boneyard Inn of Court, one of the American Inns of Court up in Orange County. She frequently speaks to lawyers and bar associations about civility in the practice of law. And without any further ado, Pam, thank you for being a guest with me today. It's great to have you with me.
Thank you. I'm really happy to be here.
Well, I want to start off with something related to your trial experience. You've tried a lot of cases representing both plaintiffs and defendants. So tell us about one of your satisfying trial victories on either side.
Well, this one's on well, gosh, I've got one on both sides, but I think my plaintiff victory, this was about 7 or 8 years ago, is probably the most satisfying.
Hmm.
This was a case, it was just a relatively minor car accident that happened on the freeway, and my client was a woman in her 50s and was starting to open up her own new business. And that business happened to involve selling shoes to older folks who had certain disabilities with their feet. Um, The defense had a lot of money. They had a big policy, and they refused to offer anything more than $10,000 to her, even though her business was completely thwarted from being developed in any sort of way that was meaningful. Um, and so we show up the first day of trial, and this is a very, very well-known insurance company with a very, very new lawyer who was very nice. And for some reason, I think this particular insurance carrier was out of state, didn't know about Orange County jurors, and stipulated to a bench trial, which in this case really worked to our favor. We had a very experienced trial judge who took all of our testimony into consideration regarding the loss of income. There was really only about $8,000 in medical bills, but we were able to board over $700,000 in lost income, and the judge awarded it to her. We had a gentleman who appeared by video who was her supervisor at the job she was leaving, and he knew all about what she had planned, and he just did a great job testifying. And the best part of it was when the bailiff was reading the verdict, realizing we had won, and I turned around. She was sitting behind me, just looking around. She didn't realize what was even going on, and I looked at her. I made eye contact. I said, "You just won a lot of money." So, oh, then the tears started, and it was she was just a nice person. She had been hurt, and the insurance company was not listening and not paying attention. Um, and I forgot to tie in the part about her, the business was actually helping elderly people with their shoes.
Right.
She had to get down on her hands and knees and help them get these shoes on their feet and carry these. They were doing trunk shows to different assisted living facilities where she'd have to haul these shoe trunks. She couldn't do it anymore. So what
Wow.
seemed like a nothing to this insurance company turned it into really something. So um, that was satisfying. That felt good.
Well, now you've been on both sides. I have too. I started off doing defense work, didn't stay in it 18 years like you did, but I think one of the things that I've always enjoyed representing plaintiffs, and it sounds like you do too, is you really get a lot of satisfaction because you're making a difference in somebody's life.
Yeah. Yeah,
And
that's for sure.
you really got to make a big difference in her life.
I did. And it felt really good. You don't I mean, the rewards are different on the defense side.
Right.
You have fraudulent cases that come up, unfortunately, and those are the ones that I really sunk my teeth into on that side. But when you have somebody who would never be able to negotiate through this process on their own, would never be treated fairly, never given a fair settlement offer, and you have the knowledge and ability to step in and help them, there's not much more I can say that's more rewarding than that. It, it's why I think it's why I do this. It's why I became an attorney.
Yeah, I think I agree with you 100% on that. Now, in talking about your background, obviously you've been involved for many years with the ABOTA, and you're still involved at a
Mhm.
national level and local level. But why don't you talk a little bit about why is a ABOTA important to you? Any thoughts on that?
Yes, I have very strong thoughts on why I think ABOTA is important, and a lot of it, well, most of it has to do with the educational arm of ABOTA, which is the ABOTA Foundation, which is in charge of putting together educational programs to promote civility in the practice of law. That is something that nobody can argue is lacking and is needed, and it makes our jobs much easier. I like to think of it as myself and the attorney on the other side. We're all in this together. Why not just get through it by making things a lot less difficult by treating each other as human beings? What's more important, I think, about what ABOTA does, and our chapter in particular takes it a step further. We go to law schools and we teach Civility Matters, which is a program put together by ABOTA. We teach it to law students so that before they even set foot in a law firm or in a courtroom, they're hearing about why it's important to be to be civil and practice with civility. They take it even a step farther. We've gone to high schools
Mm,
where they're not teaching really civics anymore.
right.
We go to the elementary school level, and we talk to them about civility as well, on their own level, of course, and expose them to what the law is. A lot of these kids don't really get much of an education about the legal system, how the court system works. That's another thing for our teachers' law school, but all of the educational programs, civic summit that we do in a major US city every year, DC, Chicago, all designed to, and I think it's important now more than ever, to teach our lawyers and our future lawyers and future citizens of this country how to be civil to each other and why that's important.
Yeah, I think ABOTA does a great job nationally and also in all the chapters in working on those things. Our San Diego chapter teaches civility to law students and high school students as well, but
Oh,
it's a
great.
great program. And I think I think trial lawyers who are members of BOTA can teach people in our country how to be better citizens
Yes. Yes, I
by
agree.
teaching these things. Now, when you're Pam, when you're working on a case, every trial lawyer who really tries cases, they're kind of working on the case and getting ready for trial from the very beginning when they first get involved in it. But there comes a time in a case where you realize, okay, this case is going to go to trial. We've tried to settle it. You may have a few months or whatever the time period is, but when you now know it's time to do the final preparation for trial, what's your process? What's your routine that you developed? How do you get ready when you're getting ready for that trial so that you're ready to go when the judge says, let's bring in the jury?
Yeah. Um, I just start by going back to the very basics of when I first got the file. I go through all of my notes of my first interview. I re-educate myself on, why I took this case to begin with. And then I just tear the whole thing apart, tear apart the medical records, organize everything. I start by putting my exhibit books together,
Hmm.
and then form my questioning for each witness around the exhibits. Those are just procedural things, but the theme of it there is to, because we start on a file and then sometimes we never really go back and look at it how it was when we first got it, and we forget a lot. And I think that's important because you're getting in touch with who this person was, all over again. Um, and then just when I start digging into medical records, I'm looking for things that are going to be a problem for me.
Right.
Let's say there's a prior injury that happened to my client maybe 2 years before she was rear-ended, and she had a neck problem before. How am I going to diffuse that? And I usually do that by I bring that up early on, whether it's in voir dire, whether it's an opening statement. I get that out there, and if there's any sort of thing that I think the defense is going to cling on to as their impeachment or trying to poke holes in my client's credibility, that takes all the steam out of it. I mean, I think we all kind of learned that in law school, but I think it's
Or
super
after law
important.
school.
Yeah, the first time it gets brought up and you didn't know about it. But I think that comes from, the 18 years I spent as a defense attorney.
Right.
And, I haven't really changed a lot of my ways. I know everybody thinks plaintiff attorneys work up things differently than defense attorneys do, but I think it's important for a plaintiff's attorney to look at the file and the records and the bad things as if you are the defense attorney, and anticipate what are they going to do with this and how can I make that less powerful.
Yeah, I think you're absolutely right. And having done the defense side, I could do that too. And I think you have to always try to anticipate, no matter which side you're on, what will your opponent be doing and what do you need to do with your client, your experts, and presenting your case to help neutralize what they're going to try to do to hurt your case and help their case. And that's great. You're doing that and getting ready. Now, when you're going over depositions, um, Some trial lawyers say, no, I'm going to read every deposition myself, make my own page and line summaries. Some go, no, I use paralegals, do that. What's your approach for going through the testimony in the depots?
I have a hard time delegating, so I do it all myself. Um, and I haven't really taken advantage of all the AI stuff out there because I don't trust it. I have trust issues, um, maybe. But now I go through every line of every depot and, kind of draft my direct exam or my cross exam depending on the witness. I think, and this is how I went to law school. This is how I went to college. I would take all these notes and then it was time for finals, I would go back and read them every word all over again and
Yep.
just condense it. So that's what I do. I'm very, very hands-on. Maybe it slows me down. Maybe I'm working too hard, but ultimately it's important because then there's that one day you're sitting there in trial and a question comes up and I wouldn't have known it had I not seen everything in the file. I
Well, I
mean,
think you have to be true to yourself and
yeah,
whatever your process is. I mean, I'm more detail oriented like you, and there are some other people who don't get into the weeds as deeply, but if it works for them, that's fine, but you got to be who you are. And
yeah,
so that's worked very well for you.
yeah,
And I happen to agree. I think if you're going to do direct and cross exam with witnesses, I think you got to read that
yeah.
depo
Oh,
and
for
you
sure.
have to know what they said and be ready to go. Well, so it looks like in getting ready for trial, you're getting all your exhibits ready, you're getting prepared to go, you're getting your voir dire ready. Now, it's common for lawyers on both the plaintiff and defense side to be working with some trial themes. And have you and your plaintiff's work had some trial themes that you thought were successful? You probably have different themes for different kinds of cases, but what's your experience with trial themes that you think are good?
Um, that's you're right. That's very case dependent. But when you say trial themes, I did try a case a few years back that was a red light dispute case, and I wanted a theme that made, well, those are the words I used. The words I used was this is what makes sense because for the jury to believe us, it had to make sense. So every time, opening statement, I would, my client says, as he approached, he saw this and, cars that were stopped on the other sides and et cetera, et cetera. And I would finish it with, because that's what makes sense.
Mm.
And, whether it worked or not, I don't recall. Did I win that case? No, I lost that case. But the theme was, this is what makes sense. So, if your case is a malpractice case, or if it's a red light case, or if it's um, yeah, the theme is gonna depend. And not all cases are gonna really fit into that. I'm sitting here trying to think of any other ones I've had that you might be able to put a theme to it. But that one, it had to make sense to them for them to believe it. So I just kept repeating it over and over. I guess they didn't believe it, but I tried.
And your theme in that case also works with this area because if you are going to use the theme has to make sense.
Yeah, yeah, yeah. I think the theme made sense, but you can only control so much at these trials. I don't think they liked my client very much. He was a little snippy on the stand, and especially in those kind of cases, they're just looking for that one thing.
Right.
Because red light. I mean, nope, I had the green light. Nope, I had the green light. It's all going to come down to whether they like him and whether they feel they're credible. And they just didn't like my guy.
Well, on the plaintiff side, um, I had the hubris when I was younger in handling some plaintiff's work after I'd left the defense side of thinking, well, if I don't like the client that much, I can clean them up, but you really can't change them. And if they're not a likable person, that's really going to hurt your case on the plaintiff side. Don't you agree?
Yes, I mean, there's some that you can help with their presentation and their demeanor. Um, and then there's others that they can't help themselves.
Right.
Eric and I tried a case. My husband, Eric Traut, you interviewed him as well. Um, and I think it was one of the first sexually transmitted disease cases in
Mm,
the state of California.
mm.
And I covered a couple of depots for him. It was really Eric's case, and he wanted me to help him try it. And I think it was because he really needed help with his client, who was the woman, the scorned woman, who was contracted a STD from her husband at the time. I sat in on her depot. I drove her here and there, and appointments, etc. And I told Eric, "Why did you take this case? She's awful."
Mm.
And he goes, "Well, you're going to help me, prepare her." So I read every word of her depo, and I pulled out every answer that I thought was snarky, snippy, kind of, was not going to be received well. And I did about 10 of them. There was more, but I took about 10 of them out, and I brought her in with her daughter, and I said, "Okay, this is how you answered these questions, and I don't want you to do this." So I went through every single one of them. And she tended to wear, a lot of too much makeup, and she was very, very boisterous. And I said, "You have got to play a different role in this." And I spent days with her. Shows up for the first day of trial. She's got a nice outfit on, very soft, no more dark eyeshadow and false eyelashes and all that stuff. And she did a fantastic job. She really did.
Wow.
And we won the case. So you can fix people, I think, for a while they're on the stand. And then there's other ones, that we tried and tried and we just can't, they're just going to be who they are. But
Yeah. Some you can fix, but there's some you can't.
no, she really and I appealed to her sense of, I know you're mad. I know you're really mad at your ex-husband for this, but if you want this to go your way, you have to behave differently. I'm sorry to have to say it, but
Yep.
she believed me. She goes, "Oh, I know I'm rough. I'm kind of rough." I go, "You are rough. So let's just, do it this way, try it my way." And it worked. So,
Good for you and good for her that she could change. So
yeah.
you've tried a lot of cases, Pam, and everybody has some different opinions, but I want to ask you this question, and that is, in your experience, what part of the jury trial is the most important and why do you believe that?
Can I pick two?
Sure.
Because I've always believed the opening statement is incredibly important. Um, there's been surveys done of jurors, and I'd say that the results were that 80% of them make up their mind based on what they hear in opening statement.
Right.
But before you even get there, I think the voir dire uh, part is incredibly important, to get rid of those people who just are not going to be fair. And it's truly an art. I wouldn't say I'm great at it. I think Eric is excellent at it. And when we do try a case together, I always give that part to him. But it's talking to these jurors and getting to know them and really ways where you don't come across as being prying or invading their privacy, but you're eliciting answers from them without them even knowing that you're doing so. That tells you, okay, this person can't be fair.
Right.
Um, and then getting them off for cause, as opposed to having to wasting a peremptory.
Well, it's certainly an art. I agree with you on that. Now, in terms of talking to jurors and asking them the questions, when you have somebody talking and you think this person, I think I can make a challenge for cause, do you do anything to try to make sure you get them committed so much that the judge can't rehabilitate them later on? What do you do to try to accomplish that?
I'll ask a series of questions that sort of pins them into a corner, and then when I realize that that's what it's going to be, my question will be, and based on that, do you feel you can't be fair towards my client? Is that correct? And once they say, "Yeah, I don't think I can be fair," and they'll admit that, um, then they're gone.
Yeah, well, that's great. So, in terms of the opening statement, and let's go through a little bit with the getting prepared for voir dire and the trial. Um, I would presume that you have used focus groups and do things like that. And what do you use them for? and how do they help you prepare for that trial and the voir dire and everything?
We've done two or three, Eric and I, mock juries, really. I guess you could call it a
Yep.
focus group.
Right.
There's a company that'll bring in these jurors and we just put our case on. It's obviously very abbreviated, and he'll take the plaintiff side, I'll take the defense side. And it's really our goal to put the worst stuff out there on both of our sides and just to see what these people think of the case. Um, we've used that as a tool to actually settle cases before. I know Eric got a case settled by, we had a recording of the mock trial
Hmm.
in a particular case he wanted to settle. And he was able to get the other side to get on a Zoom call. We played it for them. And he just essentially did, here's what this is going to be my closing argument, et cetera, et cetera. And they settled the case. I mean, they were dug in before they saw that. I haven't heard of people doing that before. They usually use the mock trial to educate themselves on their risks, their exposures, things like that. But then taking it a step further and actually saying, hey, well, here you go. We did this mock jury and here's what happened. Um,
That's a creative use of that. I think that
yeah,
was a great idea.
yeah.
Now, in terms of juries, we've gone through the COVID shutdown for several years, and we've been out of it now for a few years. Have you seen, in your experience of trying cases since we came out of shutdown, that do you feel juries are acting any differently than they were before COVID hit? And if so, what have you noticed?
I think for a while they were, and I think it manifested itself. And I thought this was strange. It manifested itself in bigger jury verdicts. When they were finding in favor of the plaintiff, they were giving more money.
Uh-huh.
And in my mind, when we came out of this, started to come out of the pandemic, I thought these jurors are going to be less sympathetic because they're comparing what's happening to my client to what has been going on in the world, people dying, um, and
Hmm.
all the impact of COVID. But I was wrong. It may be, I mean, I don't want to assume any psychological impact on a juror's mind from COVID, but I feel like maybe it just kind of switched people's way of thinking about injury and impact on your life because suddenly their lives were impacted by this pandemic.
Right.
So maybe that's why. I don't know if that's carrying over still, but as of 2024, I know that some of these verdicts were incredibly large um, post COVID.
Yeah, well, it will be interesting to see what happens as time goes on. Maybe it's going to
Yeah,
go back to the original balance point. Maybe it won't. We'll see.
yeah.
See what happens. Now, one of the things you mentioned earlier is you will wisely bring out bad issues or facts in your case and try to do it pretty early. Do you try to do that in mini openings when you give a mini opening?
That's my whole goal of a mini opening. Well, first of all, to teach the jury about what this case is about, but I put all the dirty stuff out there because then I can get rid of those jurors because they're going to hear that and I'll say, well, you heard me say dot dot dot. What did you think about that? Well, I think that's unacceptable and she shouldn't even be here. Or da 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 da. Gone. So that
Yep.
educates me on who needs to leave.
Right.
So that I think is the most important part of the mini opening is to weed out these people who can't be fair or have already made up their mind.
So the mini opening, in your experience, they're pretty short. So your trial judges, what range have they given you? Like 3 to 5 minutes, something like that?
Yeah, generally around that. They don't want, I mean, they have to let you give them now, at least here in Orange
Right.
County. Um, but they're restricting them. They're pretty short. I mean, I keep mine under 2 or 3 minutes.
So in that 2 to 3 minutes that you're talking, though, it sounds like you're probably you're giving a little overview of the case, but you're really getting all the dirty laundry out there,
Yeah,
making sure they hear it, right?
yeah, yeah. I think that's important. And that's the same in regular opening too.
Right.
I'm going to start putting that stuff out there because, I like to point out the defense is going to try and convince you of this, and they're going to talk about this happened, and yeah, that happened, but here's why it's not significant, or, just to diffuse it, get it out there. Because I don't want them hearing it for the first time on when my client's being cross-examined like a deer in the headlights.
Right. And that goes to an issue that is real important not only for your client but for the trial lawyer, and that's the issue of credibility. So when you're in the courtroom, you have to build trust with that jury. They have to feel that you're trustworthy in telling them the truth. And if you don't reveal something and it later comes out by the defense lawyer, that doesn't help you. That hurts you in credibility, like you're
Yeah.
trying to hide it.
And they're looking. I mean, I tried a case in January, and the medical bills that we entered into evidence contained, and I don't know why I didn't think of this ahead of time, but it had like an indication that insurance, had paid.
Ah,
And we talked to the jurors after our verdict, and one of them said that they thought we were trying to collect money that had already been paid by somebody else. And it wasn't even, it was like a stipulated dollar amount essentially. And something, they saw the word insurance in there, and oh,
mm,
this has already been paid. And now they want the other guys to pay for it too. And and that killed it. I mean, we ended up getting defensed on the case, but it's just crazy the things that they see and that they think of. So,
yeah. And you never know. They're going to see everything, and you
yeah.
just never know what they're going to focus on. Now, being representing the plaintiffs now, which you have for many years, you and Eric and your firm, you're only going to take a case to trial if there's some significant damages. But one of the questions that plaintiffs lawyers always have is, well, when do I first bring up the kinds of either dollars or the range of dollars we're going to be asking? How early do you do it? And why are you doing it then strategically?
Very early on in voir dire, I bring it up. I don't want them getting that sticker shock in closing argument when I suddenly ask for, $2, $3 million, and, it's not adding up with them. I want them to have heard it from the get-go that, maybe I can't use a dollar amount because sometimes there's that motion in limine that keeps that out. But I will say, we're asking seven figures. We're asking for a substantial amount of money. We're asking for, something that gives them an indication that, we're not here over a $50,000 reward, award. We want more. So I think it desensitizes the jury in a good way, to where they're not shocked when they're hearing it for the first time during closing or on a
Yeah.
jury verdict form.
Yeah, you don't want to shock them there.
Yeah, and,
Um,
and and they do, some jurors, well, I think a lot of jurors struggle with how to calculate general damages.
right.
And some people might think that $10,000 is a lot of money for somebody who's had, their life completely turned upside down, had to have surgery, can't do this, can't do that anymore. I think $10,000 is pretty good. And I think when you're talking these bigger numbers all through the trial, they're hopefully realizing no, $10,000 is not that good in this particular case. Yeah.
Yeah, you definitely have to talk to them early. In terms of when you're doing your voir dire, have you had any experience with some of the younger generations that we're starting to see in the courtroom? And do you have any thoughts on what they're like as jurors?
Yes. In fact, I co-chaired a committee that put on a seminar in Austin last month or
Hmm.
earlier this month. And the title of the seminar was The Next Gen Jury. And the very last group of presenters came in and really pointed out the reasons why the next gen jury, the younger jurors, are so much different than, you and me. Um,
Right.
so in some of those, I mean, one that I thought was really interesting is just changes in psychological strength and resilience in younger jurors. In other words, we grew up in harder times. We didn't have instant gratification. We didn't have cell phones. I mean, certainly I didn't have a tough upbringing, but we formed more of a strength and a resilience for things than the younger generation is now. So
Mm.
they don't have that sympathy or relatability to suffering, because they're given, trophies just for showing up and participating. They don't have to, win something to get a trophy. They just have to show up. So just the strength and resilience of the younger jurors is a lot different. What's important to younger jurors these days has really changed. Gender, for one, college age people, the gender back in the 1970s was 58% men and the rest were women. Now men make up 40% of college age folks.
Mm.
Um, Things that mattered to jurors when you and I were growing up. Kids in the 70s, like things like people having children out of wedlock. That was a huge deal. It doesn't matter to people as much these days. Religion doesn't seem to matter as much. Trust in government really isn't there. Trust in large corporations has shifted significantly. So yeah, I mean, the new jurors, the next gen jurors, they don't think the way that we think. Things are not important to them, uh, that are important to us. And if you think about too, like, where did we get our news?
Yeah.
Walter Cronkite,
Right.
reliable news source. They're getting their news from Joe Rogan,
Yep.
and folks like that. So there's a lack of trust in jurors that are of the younger generation, and yeah, I think it's a really interesting um, contrast that attorneys have got to pay attention to now, because they're just not the younger juries, the Gen Z or the Gen X or whoever they are. They're not made up like we were.
Right.
Their thoughts are different. Their thought processes are different. My legal assistant is a Gen Xer, and she gives me little classes and lessons on how to relate to that generation, and it's kind of fun. It's
Well, that's good. You've got a translator right there.
Yeah, pretty much. I speak Gen Z now, sort
Yeah.
of.
So, in terms of voir dire, one other thing, do you guys ever use jury questionnaires, and how do you like using them when they're allowed by the judge?
I have literally never used one.
Hmm.
Uh, I think they're important in cases, maybe higher profile cases, cases that involve um, more complex issues. Um, because the judges are now so thorough, I've found in their
Yeah.
questioning before I even had a chance to get to them. Um, I just don't have a lot of experience with those. I've never personally used one.
Well, my experience with them, and judges didn't allow them a lot, but when they were allowed, I thought we got the most honest answers from the questionnaire and the second most honest answers to the questions the judge asked. And then they were least trusting of what we asked as lawyers.
Got their guard up as soon as we open our mouths.
Yeah.
Yeah.
Well, let's go to the opening statement. That's one of the things, in addition to voir dire, that you think is very important. So, what is your strategy? What are you trying to accomplish in your opening statement? How do you tell the story, and how do you get that important first impression?
Yeah. So I tend to kind of go chronologically with my opening statements. I like to use timelines, especially in cases when there's a lot of medical treatment that's significant and in terms of when it happened, or
Yeah.
if there's prior injuries. Um, I like to get that all very chronological. I'll start at the very beginning and move through. And I feel like my job with an opening statement is to really give a roadmap, because the evidence is not going to come in like that. And I
Right.
tell the jurors that, I'm going to give you a roadmap now because the evidence in this case is not going to come in like you might expect. And so you're going to get a piece here and a piece there. So let's just talk about how it all happened and when it happened first. And then, when you're suddenly this expert witness comes up out of nowhere and you don't even know who it is, you'll know, what this is about. So that to me, I need to orient the jury as to what they're going to be hearing, what happened to my client. Um, and I do kind of stick to the old rules. If you don't get an objection, some attorneys will just they'll argue in their opening statements. Um, but I kind of try and stick to the way I learned it in trial practice in law school, and that's just you just say what happened and um, get all the bad stuff out there. Um, but then also get the good stuff in there too. So they know
Right.
you're not just there, you're not just wasting their time. To me,
Right.
that's so important that a jury doesn't feel that their time is being wasted. Um, I think I answered your question with that.
Yep. I think that's very important. You make them feel like they're here for an important task, and
Yeah,
they are.
they are.
Now, every case, and it's usually every case on each side, plaintiff or defense, have some good facts, but have some bad facts. How do you deal with bad facts and try? You've already talked about bringing them out early. Any other what things you do to deal with them, or is it just bring them out early and try to, lighten the sting?
Yeah, and I like I mentioned before, yeah, I do. I want to get them out there. But I've actually done this with the old-fashioned way where I had those big pads, what are those things called? Where the boards where you're writing on the paper, you can flip the paper over.
Right,
Um,
butcher paper.
gosh, yeah, I can't think of what they're called, with the marking pens and the whole thing. So we had a case where timeline was very important. We had a client that got in a car accident and developed these stroke-like symptoms. And she had a history of this happening to her before on a
Hmm.
couple of times. So what I did was um, with each witness, I would go up and add to the timeline. And so, yes, she had this problem before, bad fact for us, but it resolved by this point in time, which was, however long before our collision. And so just putting it up there in front of them so they can go, well, yeah, she had this problem before, but now then they can look up there. And the thing was up the whole time during the trial, this big
Right.
giant pad of paper with all of my bad facts on it, but they could see how remote in time these things were. So that's another way to do it. You're just putting it right into their mind. And
Well,
like,
that's a benefit of going the old-fashioned way because if you have the paper up there, it usually stays up the whole time unless somebody takes it
yeah.
down.
Yeah, and and some judges hate PowerPoints. They hate these. They think there's. I mean, I could walk up and just draw it on a piece of paper. That's fine, but having it all typed up nice and neat on this PowerPoint, oh, I don't want you to do that. So okay, fine. I'll pull out my pad and paper, and it'll sit there, and they can look at it the whole time. Yeah,
Yeah, judges have a whole lot of different things. Now, I like to use, digital presentation and show things digitally, but, it's not up there all the time. So
yeah.
there are benefits and detriments.
Yeah, yeah, blow ups the same way. Like we
Yeah.
have a surgery case that we tried recently, and we had the blow up of my client's eyeball with the retractors and the everything up the whole time. They were staring at that and thinking, "Oh God, what if I had to go through that without you even having to say it?"
Yeah.
So
No, that's great.
yeah.
Now, what if you get a defendant who's pretty sympathetic on the other side? How do you deal with that?
Mm, I tread very lightly. I don't beat up on them on cross exam. I think it's worse to go after somebody that the jury likes. Um, but there are ways of bringing out the bad facts with them without being aggressive and without appearing, I did yeah, I was just trying to think. There was a case that I defended. No, no, I was a defense attorney, but it was a plaintiff case I tried. And the defendant was driving this car and he was nearly 100 years old and there was
Hmm.
no business driving. um, we didn't call him under 170.6. We just, not 170.6, but God, what is that code section when you put him?
776.
Yeah, 776. We didn't call him. They didn't call him because it just looked bad, but they wanted the jury to meet him. And he was only there on day one. And once we impaneled the jury, he came in and he just comes hobbling up and waves to the jury and says hi. And my thought was, oh God, he's just adorable. They're gonna love him. But no, they did. They loved him. They thought he was adorable, but they also thought there's no way he should have been driving a car.
Right.
So he plowed into my client at freeway speed and just destroyed her car, destroyed her neck. So, it just sort of took care of itself. I didn't have to do really anything. I'm like, sure, bring him in, just have him say hi. But then
Yeah,
there's times when,
that worked out fine for you in that case.
yeah, yeah, it did. It worked out well in the long run too. But yeah, I mean, sometimes you just got to soft pedal those and get them up and down as fast as you can. If I'm going to cross-examine someone like that, I'm not going to do it for long.
Yeah. So now in presenting evidence and you're talking to the witnesses and you're doing your direct exam or cross exam. Now, cross tends to be more fun in trial, but they're both important. So, do you think there are some things that are important in direct exam that maybe people overlook?
I hope not. I mean, I think direct exam is probably the easiest thing to do, but I don't know that everyone does it effectively.
Yeah.
Some people don't like doing it because they think it's so boring, but this is where I bring in the prep your client part. Because sometimes they don't, they're so nervous and they're not elaborating. And when you're trying to get the general damages out there, which is the meat of your verdict, obviously, they just kind of clam up.
Right.
And, I work with them ahead of time, because they're so used to me saying to them, just answer the question, don't elaborate, yes or no, blah, blah, blah. But I
Right.
always tell them when it comes to talking about the impact on your life, this is when I want you just to unleash, and then they're just, well, what do I say? And I'm like, well, describe yourself. Like we had one guy who literally described the the machinations that he had to go through just to wash his own car.
Ah,
And it was fantastic. I mean, the description that he gave, just step by step, and then I have to do this, and then it hurts, and it da 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 da. And just by putting it into real life like that, on a direct exam, I think that's the most important thing is getting out, making it relatable to people who are sitting there who may have never had pain in their life or never had an injury in their lives. That's a
yeah.
hard thing to do.
You have to tell the story in a way that they'll get a picture of their mind of what they're going through or what they're suffering, and
Yeah.
even if they've never suffered something like that. So I think direct exams are real important. I agree with you. You really have to prepare your client and teach them. And you're right. You tell them don't volunteer anything so much when they're deposed. You got to
Yeah.
retrain them to say, hey, when I'm asking you questions, talk about
Yeah.
this.
Just blah, let it come out.
Just
For
let
sure.
it come out. So
Yeah.
let's go a little bit into the cross exam. And when you're talking about cross examination, um, first, do you have a preferred way you like to impeach witnesses when you impeach them? Because you could do it with, reading the depo. You could have them read the depo. You could show the depo transcript. You could show a video clip of the depo. What kinds of things do you do to impeach witnesses? And do you mix it up or do you use the same strategy?
I mix it up. I think it's important because to do that, because you got to know what kind of witness it is. Impeaching an expert, way different, obviously, than impeaching a defendant or an
Yeah, very
eyewitness,
difficult.
a police officer. I just find that if I'm going to use deposition testimony to impeach them, if the judge will allow it, I want to use video Because I don't know that all the jurors, even though you tell them what a deposition is and that they're sitting there, they're sworn to tell the truth, just reading it, if they step in it, up on the stand and say something that's completely contrary to what they testified to before, and I'm just sitting there reading it, it's way less effective than all of a sudden there they are, um, being asked that same question and answering it differently. So I like to do that. Um, that I think is way more effective
I
than.
agree with you. I think video clip impeachment is the most effective
Yeah.
because you've probably just asked the same question you asked in the depot because you
Yeah.
want to make sure you do it right. And then they say something different. And now they see on the video, they're saying a 180-degree different
Yeah.
story when they gave their depot.
Yeah. I, this was my first trial. So we're talking back in 98-ish.
Hmm.
We had the worst clients. It was a defense case. It was a woman was raped on this apartment complex property. Our clients were the worst of the worst. And when they gave their depositions, they were asked things like, this was like the owners of the building, do you think that security of your premises is your responsibility? No, no, absolutely not. I don't think that. All on videotape. So you can imagine other questions like that. So she's up there on the stand getting cross-examined, and they ask the question, do you feel that security of your apartment complex is your responsibility? Yes, yes, I do. He just snapped his fingers, and there she was up on the screen denying the same thing. And we got just hammered in that trial, but uh,
Yeah.
that's super effective. But you got to have a tech person who knows how to do it right. Because if there's too much delay between the wrong answer and the depot answer being played, it loses its effectiveness. So, if you're
No, you
coming.
have to have it queued up and you have to be prepared for it. And also you have to be very careful in taking your deposition because as you know, and I know, a lot of times you'll ask a question and the witness starts to answer, then they go into other things. You don't want that. That's not a clip
Mhm.
you want to show. You got to be very patient and go after them, say, I'm sorry, let me ask the question more clearly. Ask it you in a clear question, clear answer. That's your clip.
Yeah,
You don't want anything else in there. You
exactly.
really got to fight to get that in the depot. And if you're going to use video clips, you got to realize you got to get that. You got to be thinking like a video
Hmm.
editor in the depot.
Yeah, you can't take the depot like a depot.
Right.
And if you're going to use it, that's a whole other thing too, is when you have a witness who's not going to be available and you set your own witness's deposition.
Yeah.
um, and you notice that the other attorney that you're going to be using at trial, a lot of times they're not prepared to do their cross exam. And
That's
so
true.
this is what happened in my trial that I told you about, was my most rewarding experience. Is I had that one witness and I deposed him as if he was on the stand, and there were no cross-examination questions by defense.
Really.
So the only testimony that came in was my direct, and he didn't make
That's
a single objection.
that's
So,
great.
so it all came in. And he, like I said, he was a new lawyer, but I bet he'll never do that again.
Yeah, that was
Uh,
a good gift they gave you.
yeah.
Well, now you mentioned earlier under California law with Evidence Code 776, in your cross, you could call the defendant up on the stand and cross-examine them in your case in chief as a plaintiff early in your case or whenever you want. Have you done that? And if you've done that, and I've done it in different cases, but there are pluses and there are sometimes minuses. What have you observed about how helpful 776 is, or sometimes what are the detriments?
Yeah, I've done it in a few cases, and I think it's best utilized when you have a defendant that you is not likable,
Yeah.
because that's the first thing that the jury sees. And I made the mistake as a young lawyer of not deposing the defendant in the car accident case because they weren't disputing liability. They were only disputing damages. So I thought, well, why do I need his depo? Well, and I learned that when I put him up in my case in chief, and he was super sympathetic, and I couldn't touch him. And so I think it was very ineffective. It backfired on me
Yeah.
hard. But then we also did it recently, a case Eric and I tried earlier this year with a doctor defendant in a med mal case who was not likable. And I did depose him, and he was very unlikable. And we put him up there, and he proceeded to just dig himself a giant hole. So I think it's going to depend on your defendant, um, whether they're likable or not, whether it's going to work.
Yeah, I think that's an important factor. The only thing that's always difficult with 776 is you may be making great points in your cross-exam of that defendant, but then it's if the defense lawyer decides to go ahead and do their direct right then,
Yeah,
now they're putting on their case and
yeah,
you're just in your case still. So they can score some points too.
exactly.
Yeah.
And most of them are smart enough to do that. Some
Yeah.
of them aren't, they well, we'll just wait till our case. Um, so yeah,
That's pretty effective if they do it right then because they're kind of getting their stuff in
mhm.
earlier than they could. Now, when you do your cross exam of witnesses, Pam, I think of cross as two major varieties: the closed cross that everybody is taught and most people do, but then you've got the lawyers like we recently lost Jerry Spence. He would cross-examine people in an open style, I would call it, where he's not trying to control them. He's more telling his story with this question. Do you use one or the other, or tend to just use one, or what do you do?
Um, I don't really do a close crossed, probably more open style. Um, it tends to be a little less organized that way, maybe, but
Mhm.
and I do it's good. It depends on the expert. And I'm thinking specifically of expert witnesses on cross, because a lot of times they will try very hard to not answer a question yes or no.
Yep.
And they just start elaborating, and then you're objecting, you're moving to strike. I've had to ask a judge before, please instruct this witness to only answer yes or no, and they wouldn't do it. Wouldn't grant my motions to strike. So I'm not really sure what else to add to that, but now I tend to let it flow a little more freely.
Yeah.
Um, Let them step in it sometimes, and then just bring up I like using the old research articles too, like when they testify to something that's completely contrary to proven research, etc. Um, so yeah, I don't know if I'm answering your question or not, but
No, that could be very helpful. Definitely hit them over the head with the research. Well, now we're doing the cross and we're dealing with things like that. Now we're getting closer to final argument. And you mentioned earlier something that is always something that I think a lot of jurors have difficulty with when they have to decide when it's deliberation time. They can deal with a lot of economic damages, but non-economic damages are tough for them. And as a plaintiff's lawyer, what do you do, whether it's stories or analogies or information you're giving them, what do you give to the jury to help them figure out how to put a dollar value on pain, suffering, loss of enjoyment of life, all that kind of stuff?
I have a couple of different things that I do, and it's usually kind of story form. One of them is, and you got to be careful how you do this because sometimes you can violate the golden rule, but I'll I'll have them picture themselves answering an ad in the newspaper. It'll say wanted somebody to be involved in a car accident. You're going to be hit at 40 miles an hour at a complete stop. It's going to change your life completely. You won't be able to work anymore, play with your grandkids. You won't be able, you'll have to have your spine operated on, all these things. And if you answer this ad, we'll give you, X amount of dollars. How much money would it take for you to say yes to that one ad? So you're putting themselves in that position. Um, or would you just not even show up and apply for the job? You know, there's not a single amount of money that would make me want to do that job, is the point of that. Another thing I find effective in general damages is taking each specific damage to my client, whether it be that they had to go through a surgery, that they have, not been able to work, that they can't, go to this or go to that. They've had constant pain. And I break them down and assign like, okay, this is worth $100 a day. And then how many days they've had to endure that. And I've seen jurors really, I mean, they got their pens out and they're writing it all down because they really want that guidance. That one I think is really effective. Those are the two I use probably the most.
Okay, those are great. Thank you for sharing those. So, in your final argument, and as a plaintiff lawyer, you get to make two final arguments, but in your two final arguments, what's your strategy? What's your approach? How you trying to send them off to the deliberation and give them all the ammo that they need to help find in your favor, in your client's favor?
Well, I think the most important thing is they've just sat through, it could be weeks, it could be just a few days, a few hours, depending on your trial. Um, just a ton of information, a lot of evidence. And for us as lawyers to think that they're listening and paying attention to every single thing we've said is not realistic. So I will order dailies at the end of each day and read through them and look for nuggets of evidence that, a juror could have been, thinking about what they're going to make for dinner that night and didn't hear it.
Mm,
And I will, it's sort of a roadmap again. You're going back through everything and putting things together with what matches what now,
right.
and proving up each of your elements and plugging in the testimony that proves those elements. Plugging in the testimony that shows why they shouldn't believe the defense witness, that should believe the plaintiff witness, whether it's an expert, whether it's the plaintiff or defendant themselves, and just searching for those little nuggets of testimony. And I will literally, if I can do a PowerPoint, if my judge will let me, that will all be cut and pasted to transcript form up on my PowerPoint. How do we know that this happened? Well, Dr. So-and-so said this, or in the record said this, or whatever. I like to pull that stuff in case they didn't hear it or know what to do with it, which is a strong likelihood, that the juror will hear something and not know why it's relevant.
Yeah.
So I like to do that. I love in my second closing to put the verdict form up there. And back in the old days, we'd have the Elmo and we'd actually write the
Yep.
numbers in with the pen,
Right.
I remember the first time as a defense attorney seeing that done, and I was like, oh my gosh, they can do that? They can actually write that number in there? I'm like, oh man, we're screwed, So that I think I love that. I wish that we could bring out the old Elmos and still write it on the paper because that's what they're going to be doing in the jury room, right?
Yeah.
So that
Right.
way we just do it with a PowerPoint now, but I don't think it's as effective. But I
Well,
like
you
to,
can still use an old Elmo, I guess, if you can find it.
yeah. But I think, walking them through that verdict form, because
Yeah.
I can't imagine, having no legal experience and getting this form and not knowing what to do with it. So, you know, teaching them how to use it and what it means and what the questions mean, I
Yeah,
think
that's
is
very
effective.
helpful.
Yeah.
Well, so we've covered the trial, and let me ask you about one other thing. I know that you and Eric have been involved in this, but I think you have also been involved in the expedited jury trials.
Yes.
And in your experience, what do you think are the benefits of using those kinds of trials where you have a shorter trial, fewer juries, you put things on quicker?
Well, first of all, I think you're going to get jurors who actually want to be there because you're telling them right up front, it's your lucky day. You're only going to be here for a day, maybe a day and a half. So I think we lose a lot of really good impartial, fair-minded people to these longer jury trials. So that's the first thing I think we get out of it. Second of all, they're not going to be bored. You have to consolidate a lot of information and make a very effective use of the time of getting that evidence up there. Um, and I think we as attorneys, we talk too much. We talk way too much, and we need to learn how to be concise. And I think, it maybe it's sort of a side benefit. We become better lawyers, I think, by learning how to do expedited jury trials. 'Cause we're not wasting anybody's time. We're not talking about a bunch of garbage that doesn't make any difference, and nobody's listening to it anyway. And I know they've done a ton of studies after the fact on these expedited jury trials and comparing them to regular longer trials, and the outcomes are just as well-founded and fair. So I'm glad that they're now mandatory in the limited jurisdiction cases here. Is that also the case in San Diego?
I can't tell you about
Mm.
in San Diego if it is or not, but I agree with you that I think the expedited jury trial not only gives younger lawyers a chance to get trial experience, but it also helps them learn how to put only what's important on. And you got to be fast, you got to be to the point, you got to be simple, you have to be direct and persuasive. And a lot of lawyers have this mistaken notion, in my experience, of thinking, well, the longer the trial takes, the more important it is. I don't think the jury is like that at all. You just lose the jurors.
Yeah. Yeah.
So if you learn how to do it fast and to the point, I think the jurors appreciate that. And I personally think it's something that could be used in other areas. You'd have to stipulate to this, but you could do
Yeah.
expedited jury trials in a number of more straightforward contract or other kinds of cases, and it would be a great way to get things done quickly.
Yeah. That and having fewer jurors too,
Yeah,
uh, which I think is part of the expedited jury trials. Um, they've done the studies showing that the outcomes are the same as they were if you had 12 jurors. I've done a number of them with um, eight jurors. I don't like six jurors, but eight jurors is a good number. Um,
yeah.
yeah.
Okay, well, thanks for your thoughts on that. Well, Pam, this conversation has gone by far too fast, but I
Yeah, it
appreciate
has.
you sharing all this information. I want to kind of finish us off with this question I like to ask everybody at the end, and that is, what kind of advice do you have for younger lawyers or less experienced lawyers who don't have much trial experience, but they want to become a trial lawyer? Maybe it's something you learned when you were learning in the defense firm or things you've learned over the course of your career. But what advice do you have to give folks who want to become trial lawyers?
Um, you have to be in the right firm. I think you need a good solid base of knowledge on how the whole process works of handling a case first. And I think spending a few years with a good defense firm or plaintiff firm that will teach you that. I tend to find that the defense firms seem to take a little more time with their new associates and teach them, from the ground up. And
Yep.
once you've got that knowledge, get out and do it. Don't I spent far too much time working as an associate in a law firm and didn't try cases until I got out of there and started doing plaintiff work. Or I made the decision on whether the case was going to go to trial, not an insurance adjuster. And then even so, they would pick, the partner that had the client to try the case. A lot of firms won't pay for two lawyers to try a case in a defense firm.
Right.
And if you're working for a defense firm or a plaintiff's firm, they're going to let you try the case with them. They need the help, and you're going to get the experience that way. Like I said, I mean, I didn't even take an expert depo for probably 10 years into my career
Mm,
because they wanted the big partners to do that. So get your basis, get your knowledge, go to a lot of seminars, go to the CAWA conference. There's so many good seminars there that teach you how to be a lawyer and what to do and how to try a case. And then just do it. You're going to lose a bunch of them. You can take a crappy one and try it. you're going to get your butt kicked, but you are going to learn so much. And that is the only way to get that experience to be a trial attorney, I think. But don't do it unless you got a solid basis first on what it's all about first. Yeah.
Well, you really do have to get in the arena. You
Yeah.
have to be
It's
willing to go to
scary.
trial. You have to be willing to go where there's going to be a winner and a loser, and the jury's going to issue a verdict. But that's how you learn. That's the
Yeah,
only way you learn.
it is. And it's scary, but
Yeah.
that's life. That's how
Yes.
it is.
Hey, well, that's great advice. And thank you so much, Pam, for sharing everything that you know. And you've given some great tidbits, and people will learn a lot from this. Thanks for being a guest today on the podcast. I really appreciate it.
Well, you're welcome. Thanks for having me.
Well, that's it for this episode. And until next time, do well and be well. Bye bye now.